Hello, I'm Jessica Ryan Keeney. I'm the Lassen County Department of Child Support Services attorney. I'm licensed to practice law in California only. This video applies to California only. It is not legal advice. Be sure to ask for the advice of an attorney before applying the concepts discussed in this video to your own case. This is for educational purposes only. Be sure to like the video, subscribe, ding the bell so that you get notifications when we upload future content. Today's topic is how do you actually ask for imputed income? We've done these videos on imputed income and now it's time to get real. How do we ask that income be imputed when and if we actually need it to? So I've written some notes. I could just give you my spiel, but I would repeat myself over and over again, repeatedly. So I wrote some notes so that I try to stay on topic. So you can ask that income be imputed in an actual motion, and DCSS does this in a notice of motion. And when a private party is doing it, they typically do it in a request for order. You can arguably do it in a responsive declaration, so a responsive declaration to a request for order, or a response to governmental notice of motion. Now, you might be met with the argument that imputing income isn't a topic before the court when somebody's asking that child support be modified. And I would make the argument that it's sufficiently related to modifying child support that it is an issue before the court. But just to warn you, if the court deems that it's not an issue properly before the court when somebody makes a motion to modify child support, then you're going to have to file your own motion and make the request in a request for order. We'll actually go through those 3 documents that I discussed so that I can show you where in those documents that you can actually make the request. So Family Code Section 4058B is what covers imputing income. And we have subsections 1 and 2. And this is what the court's actually going to look at when imputing income. And so I will actually cite this section in the attachment that I'm going to attach to my document, because what I wrote in the attachment isn't actually going to fit in any of the documents. So we have to do an attached declaration, or attachment 10 as several of the documents call it. And in our scenario, it's mom that we're going to ask that income be imputed to, and we're going to ask that $40,000 a year be imputed to her. And so most of the things that the law looks at are going to be covered by an income and expense declaration. So if mom's doing an income and expense declaration, then things like her age and her education level are going to, and her recent job history and her assets, they're going to be covered in that income and expense declaration. But what if mom doesn't respond and she doesn't do an income and expense declaration? Well, you don't want to be left high and dry, so you need to set this thing up so that you can hopefully get income imputed even if mom doesn't respond or do a complete income and expense declaration. And so I'm not actually going to read my sample attached declaration. I'll put a link to it in the description below, and you'll see it briefly when I show you where it's going to go in the documents, the actual court pleadings. And let's see, if you're going to ask that much more than full-time minimum wage be imputed to a party, you might want to think about if you can ask for a vocational evaluation. And I'll cover vocational evaluations in another video. But for now, what you need to know is a vocational evaluation is when a party goes and meets with a vocational evaluator and they look at the age of the party and the skills and the abilities of the party and the job market in the area that the party is going to work or the party lives. And then they determine how much money that party could realistically earn and how long it would take them to get a job in their area using their skills and abilities. And then the vocational evaluator will produce a report, and that report is hearsay. So if you actually want the findings of the vocational evaluator to be heard by the court, you often have to subpoena the vocational evaluator and have them testify at a trial. It's a whole thing. It's another video. We're not going to discuss it now, but that's what a vocational evaluation is. So let's take a look at these forms and where you actually put your request to have income imputed. Oh, before we go, the bulk of asking that income be imputed to a party is running some job searches. And so I went to Indeed.com, and in our scenario, mom has a bunch of experience as a receptionist, and she has a high school diploma and 1 year of community college, so no college degree. So I ran a whole bunch of searches, and in our scenario, we're in Susanville, which is a rural town in northeastern California. And the major population centers outside of Susanville are Reno and Redding. So I ran job searches on Indeed.com for full-time work and part-time work. I ran them within 50 miles of Reno, within 50 miles of Susanville, within 10 miles of Reno, and within 25 miles of Redding. And depending on the situation, somebody in Susanville, it may not be appropriate to consider jobs in Reno or Redding. It's really up to the court to make that decision, and it's up to the party asking that income be imputed to make the argument. But the sorts of job searches that I did were things like receptionist, secretary, administrative assistant, front desk, and then I was thinking about things like working at a store. So I did clerk, stalker, cashier, grocery, medical records, because that's another officey job, team member, customer service. Now, if you're dealing with a party that you want income imputed to that has different skills, obviously you're going to do a different job search. So let's say somebody wanted income imputed to me. I'm an attorney. They'd be doing a search for attorney-related jobs and paralegal-related jobs and legal forms jobs, possibly even adjunct professor jobs in the legal field. So you have to really think about what area does the imputee, that's the person you want income imputed to, work in? What job skills do they have? What jobs could they and should they be looking for? And don't forget that the court may just end up imputing full-time minimum wage. And so you want to show the court how many full-time minimum wage type jobs there are, and part-time, because you never know, just in case. So think about the case, think about the area, think about the skills of the party that you want income to be imputed to. Okay, now let's look at those forms and where you actually ask that income be imputed. Here we're looking at a request for order, and I'll have a link to these in the description so that you can go find them. This is an FL 300. I always go by the form name because if somebody messes up on the number, I have no clue what form they're talking about. But if they accidentally say the form name wrong, I can figure out what they're talking about. So here we go, request for order. In our scenario, dad is asking that income be imputed to mom. And so we're going to fill out in dad's, in our scenario, it's going to be dad, but in your case, it's going to be you. So we're going to fill out your name and address, phone number. If you're representing yourself, you're in pro per. Remember the county that your case is in, the street address, mailing address, city, state, zip, and branch name of your courthouse. Petitioner, respondent, and other parent are always going to be the same. We're going to ask in this one that we change child support, and then we want to check this other box. It won't let us check it. We would check the other box. We're going to have to check that by hand when this prints out. We're going to put in here, oh, that's ugly. We're going to put in here, what? This is what I get for filling out free forms on the internet. Well, now it won't let me fill it out. I think I always have a problem when I try to fill these forms out on camera for free from the California court website. Anyway, here where you see the blinking cursor, you would write impute income to whoever you want to impute income to. In our scenario, it's mother. And then make sure you put the name of the imputee here. And then we're going to check if they're the petitioner, the respondent, the other parent. If DCSS is involved in your case, be sure to include DCSS in this line. And let us see. We're not going to know the hearing date until we take this to court and have it filed. So the court will fill in the hearing date, time, department. However, if the address that the hearing's going to be at is the same as the court's address above, then we check that box. Court's going to fill out this next section. We're going to go on to page 2. We're not requesting restraining order information. If we were requesting custody or a visit, or we're not requesting restraining orders, and we don't have any information about restraining orders to provide. If we were requesting custody or visitation orders, we would check these boxes and fill that out. But in this scenario, that's not what we're doing. We are, however, requesting child support, and we want it to be based on the guideline, and we want child support for our daughter Susan Smith, age 12, to be modified, and we want mom to pay it, or whatever the situation may be. Actually, I think in our scenario it'd be dad would be paying. And then if we were asking for something other than guideline, we would fill that information in here. However, asking that income be imputed is not asking for something other than guideline. And then we want to change the current court order, and then we put the date of that order, and then we put here what that was ordering. And then we're going to have to complete an income and expense declaration. We've done a video on completing income and expense declarations. And then put in a brief little blurb here about the court should make or change the support orders because. Why do we want the court to change those support orders? And this can be something as simple as father's income has decreased. Mother lost her job 6 months ago and should have income imputed to her. Okay, we're not asking for spousal support or domestic partner support, so we're not going to fill anything in here. Oh, going back up here, if we didn't have enough room in this area to tell the court what we wanted, we would check this box here, attachment 3B, and then we would create an attachment 3B, and we would finish typing the reason here. Now, another thing we can do is we can add supporting information for why the court should decrease child support and impute income to mom. We can add that on the last page. Okay, back to this spousal or domestic partner support. We're not asking for it. We're not asking for property control. We're not asking for attorney fees and costs. Nothing regarding a domestic violence order. Other orders requested, we're going to check here and we're going to say impute $40,000 per year to mother. Okay, time for service hasn't changed, so we're going to leave that alone. Facts in support. This is where if you run out of room on that other page to explain why child support should be modified, you can explain it here. This is usually where I explain all of that stuff anyway. And we're not going to have enough room for everything we need the court to know, so we're going to check this box, attachment 10. We're not even going to bother writing anything here. We're just going to put everything in attachment 10. Don't forget to date your document, write your name, and once you've printed it, put your signature. Okay, so now what does attachment 10 look like? Here's attachment 10. We're looking midway through the document. So here we have marriage of Smith, and then our case number, and then we wrote attachment 10. You'll also hear me and other attorneys call this the attached declaration. So here's our heading. Number one, $40,000 per year should be imputed to mother. Mother has been unemployed for 6 months. She asks for an increase in child support based on her making $0 per month. This would be if we were responding to mother's request. In the scenario where we're filling out the request for order, we're the one making the request. And so in the scenario we just discussed, we would explain here that father's income decreased. Mother has been unemployed for 6 months with no income. Okay, so this is going along with our request for order. $40,000 per year should be imputed to mother. If the court will not impute $40,000 per year to mother, the court should at least impute full-time minimum wage to mother, or something between full-time minimum wage and $40,000 per year. The court should base child support on this imputed income to mother. The court may impute income to a parent per Family Code Section 4058B, which reads as follows. And I have here subsection 1 and 2, and I've quoted this for the court and for the other parties so that they can read it right here in our document. Now here I'm going to address the things that the court's going to look at, and these are in subsection B2, and there are things like parents' assets, residence, employment, earning history, job skills, educational attainment, literacy, age, health, criminal record, and other employment barriers, and record of seeking work, as well as the local job market, the availability of employers willing to hire the parent, prevailing earning levels in the local community, and other relevant background factors affecting the parent's ability to earn. So I said I wasn't going to read this whole thing. I won't. I'll have a link to it in the description, and I'll have this up on my website so that you can take a look at it, even use it to modify it so that you can use it as a template and make it apply to your own situation. So a lot of these things, as I said in section, B2, would be covered in mom's income and expense declaration. But if mom doesn't file an income and expense declaration, or she doesn't fill it out completely, we still want the court to have the information they need to impute income to mom. So we need to provide that information. In our scenario, mom and dad were married, and dad has a good knowledge of mom's employment background and her educational background, so dad can testify to this information himself, and he can put it in his own declaration. So we list mom's age. She has a high school diploma with 1 year of community college. She worked full-time as a receptionist during the marriage. In the last 5 years of the marriage, she made about $40,000 per year as a full-time receptionist. She's in good health. She's fluent in the Microsoft suite. She's familiar and comfortable with using standard office equipment, such as computers, fax machines, copy machines, postage machines, and the like. If she has phone skills, I would probably want to put that in there as well. She has no criminal record. She is literate. Our children are 9 and 11. They attend school Monday through Friday, 8 a.m. to 3 p.m. I describe here the parents' parenting schedule. I describe before care and after care programs with the school, when it starts, when it ends, how much it costs, that it's available to mom and dad. I tell the court where mom lives. In our scenario, she lives in Janesville, which is just outside of Susanville. This is important because our area is a rural area. This area is a rural area. The closest population centers, as I said, are Reno and Redding, and they're not exactly close. I mean, a drive from Susanville to Reno, I always plan on it taking 2 hours. And a drive from Janesville to Reno realistically is about an hour and a half, but you should still plan on it taking 2 hours. And a drive from Susanville to Redding is even further. So depending on the custody situation, it may not be realistic for mom to drive to Reading or Reno to go to work. It's going to be up to the court to evaluate the situation and decide if that is in fact realistic. But the court needs this information so that the court can decide if it's realistic. There are other communities that are a little bit closer to Reno in our area in which it would be realistic for mom to drive to Reno, and that would be, say, if mom lived in Doyle. Now, if you're not from the Susanville area, this probably doesn't mean a whole lot to you. If you are from the Susanville area, well, here you go. A gift to you, me explaining something specific to our area. But you can still kind of get an idea how proximity to population centers and work is going to play into this, and why and how you should explain information in your attached declaration. So the court's going to look at what's in the best interest of the children. Is it in the best interest of the children that full-time earnings at $40,000 per year or even full-time minimum wage be imputed to mom? And in our attached declaration, it's the dad's contention that it is in their best interest. It'll relieve the financial burden on his household, so he'll have more money to put toward raising the children because support will go down. And it will increase the money in mom's household because she'll have some child support, and she'll have her own earnings to help provide for the children. And overall, it's going to mean there's more money between mom and dad to help support the children. Additionally, dad wants the court to know that he doesn't think that this full-time work schedule is going to interfere with the kid's relationship with mom, and they share 50-50 custody. Dad's willing to rearrange the week on, week off schedule to accommodate mom working once she gets back to work. Mom worked during the marriage. It didn't affect her relationship with the children then, and she was still able to help raise them. Dad can pick up and drop off the kids when mom's at work. If mom ends up working outside of the area, if the kids need to come home early from school, say they're sick, dad can pick them up. So if mom's out of the area, dad can pick up some of the slack that will be left if mom's working out of the area and the kids need him. So these are the sorts of things that you're going to want to explain for why it's in the best interest of the children that the other parent have income imputed to them. In my experience, it's easier to convince the court that it's in the best interest of the children to impute income to a non-custodial parent, so a parent who doesn't have 50% parenting time or more, than it is to a custodial parent. But in our scenario here, mom and dad have 50-50 custody. So you're going to have to explain for your own case what's in the best interest of those children and why is this in the best interest of the children. So dad goes on to say he sees no reason why mom can't make at least $40,000 per year. There are plenty of entry-level jobs, both office jobs and non-office jobs between Susanville, Reno, and Reading. And then here we are going to explain the job search that dad did. So on February 6, 2003, dad performed a job search on Indeed.com. And except for the obvious Susanville jobs, he did not review the listings to weed out any duplicate listings. Now, I highly encourage you to go take the time, weed out the duplicate listings. The way I would do that is for each job search, print out all of the job listings. There could be pages upon pages of job listings. Print them all out for every single job search. And then on any of the duplicates, cross out what's a duplicate so that you only have one of the listings. And then when you list how many jobs there were in that category, make sure that you list the jobs without the duplicates, and make sure that you explain to the court in this paragraph here how you weeded out the duplicates, how you noted the duplicates, and that your number of jobs listed below doesn't include the duplicates. And then all of those printouts that you did of page after page of those job listings, you're going to serve those on the other parties. So in our scenario, mom, and if DCSS is involved, you're going to serve them on DCSS also when you serve your motion on those parties. And then when you go to court, you're going to have a copy of all those documents that you served on mom and DCSS, and those are page after page of those job listings. You're going to have a copy for the court and a copy for mom and a copy for DCSS and a copy for yourself. That way everybody is looking at exactly the same documents. That way the court can evaluate if there are any duplicates and if which of the jobs, if any, are not appropriate jobs to go into the total number of jobs available to the other party. The court can also see just how many jobs and the types of jobs that are available to the other party. And the other party can see the same thing and make any arguments that they need to make. So for this search, I did Susanville within 50 miles. And then I did searches for full-time and part-time jobs, and I did entry level. Now, arguably, mom could probably have a mid-level secretarial position because of how long she was doing secretarial jobs. And you don't have to do entry level. This is just what I chose to do for my example. And so here are the different job search queries that we did. Entry level full-time receptionist, found 5 jobs. And then we go down the list here. Here we are in the part-time. Now we're in Reno, and I did within 10 miles of Reno. So within 50 miles of Susanville, there's not a whole lot, but I figured that would cover between Susanville and Doyle. There's not a whole lot between Doyle and Reno. And then within 10 miles of Reno, I figured that would cover Reno and Sparks without sending mom into Carson City, because the drive from Susanville to Carson City is a bit of a drive. Although arguably, if we're saying she should drive to Reading to go to work, it wouldn't hurt her to drive to Carson City either. It'd be comparable. But that's just how I did the job search. And you're going to want to be sure to explain to the court why you chose the search radius that you chose. So here I searched all the same terms that I did for the job search in Susanville, but I did this for Reno. Now we come down a little bit more and we've got Reading, and I did within 25 miles of Reading. And I accidentally ran some searches within 10 miles of Reading, and there wasn't much of a difference in the jobs that I was seeing. And that's because there's not a whole lot around Reading. It's kind of an island unto itself. But anyway, again, be sure to explain to the court why you made the decisions you did with your job search queries. I searched all the same queries for Reading as well. Okay, and I listed the number of jobs, didn't weed out the duplicates. Now, here it is, my second heading. If income will not be imputed to mother, then mother should be ordered to seek work. And a lot of times people don't want to include an alternative like this because they think the court is going to see the alternative and immediately go for the alternative. And in my experience, that's not true. In my experience, I want to give the court an out. I want to give the court the ability to order something. And they're not going to order it if I didn't ask for it. And what I really want is income to be imputed to mom. But if income's not going to be imputed, then I want her to be ordered to seek work. Because what's going to happen is she's either going to find a job or she's not going to find a job. And if she doesn't find a job, and she hasn't truly sought work, then I'm going to use that to hammer mom and get the court to impute income to mom because she's not truly looking for a job. On the flip side, if mom really is looking for a job and she's doing the things that I've asked the court to order her to do and the court actually orders her to do, and she really can't find a job, then the court's going to look at her efforts and the court's going to be like, wow, you really did a good job looking for a job and you still couldn't find anything. So it would be inappropriate to impute income to you. So this out, as I call it for the court, is very important in my mind. And so what I'm going to ask the court is that if the court won't base support on imputed income to mother, then I request, this is father, that the court order mother do the following: seek full-time employment at a rate of at least 5 jobs per week, keep a log of her work search efforts, and this should be 5 different jobs. Keep a log of her work search efforts. that the log include the date she applied, business she applied at, position she applied for, name of the contact person where she applied, phone number of the contact person where she applied, a copy of the job application for each job applied for, a copy of any and all cover letters and resumes submitted for any and all jobs applied for. And so what this is going to do is, if mom doesn't get a job and dad wants to go back and look to see if she really actually did look for a job, dad can make contact with these places and find out if mom really applied. Now, dad's going to want to be careful doing that, because if he makes a pest of himself and potential employers think that the ex of a prospective employee is going to be calling their job, pestering them about the employee, they may not be inclined to hire that person. But this information also keeps the person honest and can be a good resource for that person in the future when they're going to follow up on the jobs that they applied for. Now, the reason why we're asking for a copy of the resume and the application and cover letter is so that we can see that mom's not trying to sabotage her job search. And also, those documents are going to give the court information that the court may need in the future in imputing income to mom. So we also want mom to give me, in this case it's father, a copy of the completed log with all attachments by the fifth day of each month. Notify me of the business name, address, phone number, job position, and rate of pay within 48 hours of getting a job. And then, of course, dad's going to sign this under penalty of perjury. Be sure to date it. And then his signature goes here. And this request here for the seek work order is very similar to the request that the Department of Child Support Services get. I don't believe that we ask for a copy of the application, cover letters, and resumes, but pretty much everything else we ask for in that seek work request is what we get in our seek work orders with DCSS. And if you have anything else that you need to ask the court to do, this declaration is a good place to put it. So there you go. We're going to use this declaration whether it's attached to our request for order or it's attached to our responsive declaration, but it's going to look a little bit different up in the top if it's attached to our responsive declaration. So here's a responsive declaration to a request for order. Again, all the same type of information that goes on the top of all of our court documents is going to go here, except here we're going to know the hearing date, time, and department, so be sure to fill that out so that the court gets your documents coordinated with the file, hopefully in time for the hearing. And then we go through this document. In our scenario, there's no restraining order request, no custody or visitation request, but there is a child support request. So in this scenario, now mom is asking for support based on her making no income. And let's say that mom filed the request for order and now dad is responding to it. So he's going to check here, child support, I don't request, but I consent to the following. Child support set based on $40,000 per year being imputed to mother. And then there's no spousal support request, no property control, no attorney fee, no restraining order. Mom hasn't made any other requests, so we're not responding here to any other requests. No time for service requests. Here we go. Facts and support, attachment 10, just like we did. Be sure to date, type your name, and then you're going to sign under penalty of perjury. We're going to come back here to our attached declaration, and in this situation, we're going to change this part about father's income decreased. Mother has no income. She is requesting child support be based on her having no income. And then we're going to tell the court I'm requesting, or father is requesting, that child support be based on $40,000 a year income imputed to mom. So the rest of this declaration is going to look the same. We're not going to go through it because we already went through it. Now we're going to look at a response to governmental notice of motion. So if DCSS files the request to modify child support, you're going to be doing a response to governmental notice of motion. So the top of the document pretty much looks the same in every situation. Again, you're going to know the hearing date, time, department number. Be sure to fill that in. We're going to go through and we're going to check the boxes that apply to what DCSS asked for. They asked for child support. And here again, we're going to request child support be based on mother making $40,000 a year. And we're going to keep scrolling down. None of this other stuff was asked for. If the department is asking that that income be imputed to mom, then that would be another request. And if you agree with what they're asking for exactly, then check that you do. If, let's say, you agree that income should be imputed, but you don't agree with the amount they're asking for, then you would check I don't. And then you would explain in your facts and support what you're asking for. But you can see there's no room to put all of that information. So we check here in the attached declaration, and here we're going to say see attachment. We don't necessarily need to put that because we checked the box down here, but we did. Don't forget to date and sign. Now on this document, there's a proof of service by mail. The parties can't serve this, but anyone over the age of 18 and not a party to the case can serve this. We've gone over serving documents in past videos. We're not going to go over it again, but we don't need a standalone proof of service for this document because we have a proof of service in our in the document itself. So here we scroll back up. The facts are contained in the attached declaration. We're going to go back to this attached declaration. Here it says attachment 10. We're going to make sure that it's called attached declaration so that it matches this right here in our responsive declaration. Okay, so the rest of this attached declaration in our scenario looks pretty much the same. DCSS is making a request. So in this first paragraph, we're going to want to modify this so that it speaks to the DCSS request. It's going to be dependent on what DCSS is actually requesting. Not going to go through this again. And now here you can do an attached declaration on a judicial counsel form. I'll have a link to this in the description as well. You can see that instead of doing my attached declaration or my attachment 10 on the judicial counsel form, I used pleading paper in a Word document. That's perfectly okay. Our entire declaration is not going to fit on this page, and it's pretty common for my attached declarations to take up more than one page, which is why I like to use pleading paper. But just in case you need this, I'll have a link to it. There we go. That is how you ask that income be imputed to a party and where you would put that request. So remember, this isn't legal advice. This is for educational purposes only. There may be a reason to do this differently in your particular case. Be sure to consult an attorney and make sure that what you're doing in your particular case is what's actually needed for your case and that you're not going to run your case off the rails by doing it wrong. We sure appreciate you listening to the end. Be sure that you like the video, subscribe, ding the bell so that you get notification when we upload future content. If you have any questions, comments, or concerns, you can go ahead and put them in the comments. I can't guarantee that we're going to respond to the comments, and if we do, any response will not be legal advice. It will be for educational purposes only. But regardless, sometimes those questions, comments, or concerns make their way into future videos, so we sure appreciate seeing those. Stay tuned for the next video. We look forward to seeing you. Thank you.